3:30 panel. My name is Michael Moreland. I am a law professor at Villanova, University outside Philadelphia, and I'm the chair of the Religious Liberties Practice Group that is the sponsor of this panel. If you're interested in our programming, you can go to the Federalist Society website, see lots of our recent webinars, including one on religious charter schools, one on the pending Supreme Court term in religious liberty cases. But it's my pleasure now to introduce the moderator of this panel, the Honorable Kyle Duncan. Judge Duncan received his BA from Louisiana State University in 1994 and his JD from the LSU Law Center in 1997 and his LLM from Columbia Law School in 2004. After graduating from law school, Judge Duncan clerked for the Honorable John Duhay of the U.S. Court of Appeals for the Fifth Circuit. And then prior to becoming a judge, Judge Duncan served as the appellate chief of the Louisiana Attorney General's office and as an assistant solicitor general in the Texas Attorney General's office. In addition, he was an assistant professor of law at the University of Mississippi and served as general counsel of the Becket Fund for Religious Liberty in Washington, D.C. Finally, he practiced law at the Washington, D.C. firm of Duncan PLLC and Share Duncan LLP, where he was a founding partner. He was appointed by President Trump to the U.S. Court of Appeals for the Fifth Circuit on May 1st, 2018. And with that, I will turn it over to Judge Duncan.
Thank you, Michael. Welcome. Welcome to our panel. I'll summarize what I think we're going to talk about and then introduce our distinguished panelists. Parental rights have a rich pedigree in American law dating back more than a century. Constitutional rights of parents to direct their children's education and upbringing originally arose in cases like Maurer and Pierce, which we've all read in law school, which address the rights of parents to obtain foreign language instruction for their children or to send their children to private religious or military schools. And the right has been addressed in other circumstances over the years since then, such as in the context of child labor laws or grandparent visitation. Today, the rights of parents are being tested in a new realm, that of children who experience gender dysphoria, that is, a child's perceived lack of alignment between his or her body and his or her interior perception of themselves. Sometimes this is phrased as a conflict between one's biological sex and one's internal gender identity. In recent years, there's been a widespread and robust debate over the proper treatment for this condition, whether it be psychological or social or medical. There's also been a sharp increase in the number of children experience this kind of distress and identifying as transgender. Very roughly speaking, debates center on whether the appropriate form of care for gender dysphoric minors should be what some have called a cautious wait-and-see approach accompanied by psychological counseling, or whether children should be permitted or encouraged to socially transition through the adoption of new forms of dress and new pronouns. And finally, to medical interventions, whether that be in the form of hormonal treatments such as puberty blockers and cross-sex hormones, or in the form of surgical interventions. Legally, these disputes have come to a head recently, fairly recently, in various federal cases where parents and children or other groups have raised claims, principally under the Equal Protection Clause or the Due Process Clause, against state laws that restrict hormonal and surgical interventions for gender dysphoric minors. So far, these have resulted in several district court cases in which, and I'm sure the panelists will speak more accurately to this than I am, but which largely resulted in victories for the plaintiffs. But now in 3 circuit decisions, which I believe have all ruled in one way or another for the states. Those are in the 6th and the 11th, and very recently, Chip just sent me one from the 7th Circuit today that I've only had a chance to, it was today or yesterday. Yesterday that I've only had a chance to skim. It's another split decision in this area. As many of you know, the United States Supreme Court has granted certiorari in the 6th Circuit case called Skermeti versus United States, but only on the question of the Equal Protection Clause. There are private plaintiffs that are raising the due process, but as of yet, the court has only agreed to address the Equal Protection Clause, and our panelists will discuss the issues raised by this case presently. I believe the argument is, at least right now, is scheduled for December the 2nd. But the reason I am not confident about that, fourth. Thank you, Chris. Chris is one of my clerks. No, I'm just kidding. He's one of my former colleagues from the University of Mississippi. However, as you may have noticed, there will be a change in administration in January, and that raises all sorts of questions about what will happen to the Skrmetti case. I know, because Chip sent me the article, that in the New York Times is reported that the incoming DOJ will change, or will likely change position in the case, which raises the question of what's going to happen to the case. So with all those remarks in mind, I am pleased to welcome our distinguished panel to discuss these important issues. Let me briefly introduce them, and then I will turn it over to them. To my left, Professor Chip Lupu is the Elwood and Eleanor Davis Professor Emeritus of Law at the George Washington University Law School. Back when I was sort of trying to be a law professor and writing in the area of religious liberty, I was very familiar with Chip's work and very challenged and helped by it. And I remember him early on in my career offering me a lot of encouragement, for which I'm grateful. To his left, Professor Melissa Moschella, who is a professor of the practice and philosophy at the University of Notre Dame's McGrath Institute for Church Life. Her work spans the fields of ethics, political philosophy, and law, and her areas of special expertise include natural law theory, biomedical ethics, and the family, especially parental rights. To her left, Professor Steve Sanders, the Associate Dean and Professor of Law at Indiana University Maurer School of Law. Steve teaches a wide variety of courses, including constitutional law and constitutional litigation. And he serves as the law school's faculty director of judicial clerkships, I say here, so I hope he will send me some good clerks. And last but not least, the Honorable, now I've got you here somewhere, General. There we go. The Honorable Jason Miyares, the Attorney General of Virginia, who I'm looking over this extensive biography, and I'll leave out a lot of it, but I noticed that you got your JD from William & Mary, where one of my sons goes to school, so I'm grateful for that. You have served in the Virginia House of Delegates, and you were the first Cuban American elected to the General Assembly, and the first Hispanic elected statewide official in Virginia. And we're grateful to have you on the panel. With that said, I will turn it over to Professor Lupu.
Thank you very much, Judge Duncan. My engagement with the issues we are considering began in the spring of 2023 with an invitation to a symposium at NYU marking the 100th anniversary of Maurer versus Nebraska and Pierce versus the Society of Sisters, the germinal cases about the due process rights of parents to direct the upbringing of their children. These rights are rooted in history, tradition, common law and state statutory principles, and federal constitutional law going back 100 years. They are limited by firmly established notions of abuse and neglect. At the time of the symposium invitation, the most salient legal issue in my mind was the right of parents to pursue treatment for their adolescent children suffering from gender dysphoria, a clinically significant and persistent disconnect between sex assigned at birth and gender as experienced. These are adolescents in mental distress, facing unusually high rates of anxiety, depression, and risks of self-harm, including suicide. Over 20 states have outlawed pharmaceutical treatments for adolescents, puberty blockers and gender-promoting hormones, intended to facilitate medical transition of gender identity, an established practice to alleviate gender dysphoria. Now, some issues raised by transgender identity, for example, athletic competition, fairly implicate interests of third parties. But the question of medical transition per se is all about loving parents who care for their children in a difficult situation, acting in consultation with medical professionals. Why is this the business of the state? Is the state in a position to know better how to treat a child than its parents after a broad expert consultation? Naively, I once thought libertarians and conservatives would agree that laws banning this care represent a massive intrusion on parents' rights. But I have discovered that many people who claim to be dedicated to parents' rights and limited government are quick to defer to state power when medical transition of gender is the question. Now, notice I am not talking about gender reassignment surgery, irreversible and rarely performed on minors. When I began my research, many district court judges, as Judge Duncan noted, had ruled against the states on equal protection grounds, on parents' rights grounds, due process clause, or both. Nevertheless, in the fall of 2023, the 11th Circuit and then the 6th Circuit ruled in favor of the states. Yesterday, the 7th Circuit did likewise in a case out of Indiana. For the 6th Circuit, this is the Scrimeti case, it's uncertain as Supreme Court. Judge Sutton rejected the parents' rights claims on the ground that they involved areas of traditional state regulation, the use of pharmaceutical products, and the medical profession. But the parents challenging these laws were not seeking to use illicit substances like heroin, and they were not doing an end run around medical norms and institutions. The substances used in medical transition are used frequently to treat conditions that cisgender children present. For example, girls with unwanted facial hair may be prescribed estrogen. Boys with unwanted soft breast tissue may be prescribed testosterone. They take hormones to make their body conform with their cisgender identity. Some girls have surgery, breast reduction, or enhancement to conform to an ideal female body type. This, too, is gender-affirming care. These procedures present risks, can go wrong, and may lead to regret, but no states outlaw them. It is hostility to the idea of transgenderism, not adolescent health, that is driving the laws now being challenged. In my view, parents' rights in this context should work in both directions. Parents whose adolescent children suffer from gender dysphoria have the right to choose or not choose medical transition. What they don't have is the right to ignore their children's mental distress, sometimes severe, sometimes leading to self-harm. The crucial question in this Scrimeti litigation is the appropriate standard of review. I know that Steve Sanders will address the equal protection arguments for heightened review. But my claim is that the parents' rights issue in this case also demanded a hard-look, non-deferential review. These laws fail that sort of review because of their bias. They ignore the well-established benefits of medical transition, and they don't regulate cisgender-affirming uses of the same treatment. They are not narrowly tailored to prevent abuse or neglect of children. Now, I know that developments in the United Kingdom and Europe have raised important questions about medical transition for adolescents. There are reasons for caution in prescribing such therapies. The relevant protocols demand caution in prescribing them. But other Western countries have not outlawed the therapies because there are cases in which they make a strong and positive difference. Parents and medical professionals should have the authority to decide when these therapies should be used. As Judge Duncan explained, there were 2 cert petitions in the Scrimeti case, but the court granted only the petition from the United States, limited to equal protection. Perhaps some justices had dysphoria about the parents' rights claims, which represent a conservative path to potential invalidation of these laws. The future of the litigation is uncertain in light of the election. Now, consider a related issue of when public schools must provide notice to parents of a child's request for a social gender transition plan. This is not medical transition, this is social gender transition in school, typically involving names, pronouns, access to restrooms. There are extremely difficult issues presented by this question of notice to parents and family about requests for these plans. And there's a wide disparity of policy among the states. Virginia is at one end of the continuum. The state policy is that schools must keep parents, quote, fully informed about all matters that may be reasonably expected to be important to a parent, including their child's social and psychological development. If a child presents at school as seeking social gender transition, the school officials must tell the parents without delay. As I understand the policy, school officials must also inform parents if the officials hear about gender transition plans from third parties, teachers, or other students. The Virginia policy will deter some students fearful of parental response from confiding in school officials. Schools and students in distress need a safe place to confide their concerns. The Virginia policy more broadly may turn officials, in the worst case, into spies on behalf of parents. At the other extreme is California, which emphasizes the child's rights of safety and privacy. In a case of request for social transition, under California law, public schools may not disclose social transition plans to parents without the child's consent. The California policy will encourage concealment from parents, produce significant parental mistrust of schools, and turn schools officials into adversaries of parents. My own view is that neither parents nor children have the Constitution on their side in this conflict. School discretion is appropriate. Schools and school officials are caught in the middle. They have schools to run and children to care for. Accordingly, it's appropriate to have no disclosure in initial discussion of plans if a child thinks it's unsafe. School officials should encourage disclosure, and ultimately disclosure to family is essential for coherence in a child's life. In a full social transition case, everyone at school will eventually know, and only the parents will be in the dark. Managing that process is delicate, but schools have their own imperative in doing it carefully. And parents who object to the plans ultimately have the right to choose a different school. Now, there's a cert petition pending in the Supreme Court in a case raising issues about these parental notice policies. Is my time about up?
You keep going.
All right, thank you. This is, we may hear more about this from General Miyares. This is the case of parents protecting our children versus the Eau Claire area school district. The school district in Eau Claire, Wisconsin, has the kind of nuanced policy that I have described. And it's been challenged by a group of parents, none of whom have children who claim to be transgender, but the parents claim their rights are violated by the possibility that their children might seek gender transition and the school will hide it from them. The case was dismissed in the district court on Article III standing grounds, and the Seventh Circuit affirmed that dismissal. Now, I know that Virginia has filed an amicus brief in this case on the side of the parents. I expect we'll hear more from General Miyares about it. I'm going to hold for later, maybe a false promise in this panel about religious freedom being central. It's not. It's a tangent, but there are places where it's an important tangent. And I'm hoping in the questions and discussion, I will have a chance to say something about the religious freedom issues, parents and teachers implicated by these cases.
Thank you, Professor. Professor Moschella.
Thank you. It's an honor to be on the panel. In my brief remarks, I want to first step back and look a little bit at the moral and constitutional foundations of parental rights before then turning to some of the applications with regard to the controversial issues already mentioned by Professor Lupu and engaging in a little good-natured disagreement with some of his opinions on those matters. But first, at the foundational philosophical level, parental rights are really about parents' authority to make decisions about what's in the best interests of their children. Now, it's obvious that someone has to have authority over children because they're not mature enough to make important decisions on their own. And I should note that psychological and neurobiological evidence show that this is true even in the teen years. So the fundamental question is, who has primary authority to decide what is best for children, parents or the state? The short answer is that parents have primary child-rearing responsibility and authority because they, not the state, have a uniquely intimate relationship with their children, a relationship that, in the central case of biological parents, is literally the source of the child's existence and identity. This intimate relationship grounds parents' obligation to care for their children and makes them uniquely suited for this task in terms of knowledge, motivation, and alignment of interests. And because caring for children requires making decisions on their behalf, and also guiding and setting parameters for the child's own decisions as the child matures, parents' child-rearing duties are the basis of their child-rearing authority. This is the core of the natural law argument for parental rights, and we see it echoed in common law by prominent figures like Locke, Blackstone, Kent, and Story. To borrow a metaphor from Thomas Aquinas, a precursor to these common law jurists, it's just as natural for children to be raised to maturity within the spiritual womb of their family under the authority and care of their parents, as it is for children to be gestated in the physical womb of their mothers. Like the physical womb, and in continuity with it, the family is a spiritual womb, a protected sphere within which children can grow to maturity. And so the family, grounded in marriage, is a natural authority structure that corresponds to unchanging features of human nature and deep human needs. The state didn't create that structure any more than it created a woman's womb, and it's not from the state that parents get their authority. Parents have that authority by nature, and the state has no right to take it away or encroach on it unless parents have proven themselves unfit through genuine abuse or neglect. Adoption, by the way, is the exception that proves the rule here. Because adoptive parents lack the pre-existing relationship with their children that grounds the natural obligations and corresponding authority of biological parents, the state requires that adoptive parents be vetted and licensed. And as a prospective adoptive parent myself, I can tell you that this process is extremely rigorous and invasive. And adoptive parents have to make an explicit legal commitment to take on the child-rearing duties that biological parents have by nature. But once they do take on that commitment, they have the same rights and duties as any other parent. So, the spiritual womb of the family marks out a sphere of jurisdiction within which parents have the authority to direct the internal affairs of the family community, including especially the education and upbringing of children. Children, of course, are also under the authority of the state, but parental and state authority are not on the same plane. Rather, children belong first and foremost to, and are first and foremost under the authority of, their families. And their relationship to the state is typically mediated through the family, just as, for instance, my relationship to a supranational body like the United Nations is mediated through my US citizenship. Coercive state intervention into the spiritual womb of the family's natural sphere of jurisdiction, can only be justified for reasons similar to the commonly accepted justifications for international intervention into the affairs of a sovereign state, namely to stop serious human rights abuses or serious harm to the international order. Analogously, coercive state intervention into the family sphere is justified only to stop genuine abuse or neglect, or to prevent serious harm to the public order. For instance, the state could shut down a terrorist training school or something like that. Again, we see this view echoed in the common law tradition, with Story, for instance, indicating that the state should not interfere with the natural authority of parents unless they are found guilty of what he calls gross misconduct. A second related argument for parental rights conceives of those rights as conscience rights or religious free exercise rights. Because parents have a serious personal responsibility to direct their children's upbringing, a responsibility which many parents see as an explicitly religious one, making it difficult or impossible for parents to fulfill that responsibility is an attack on their religious freedom. When the state tells a parent, "Oh, don't worry if you object to what the school is teaching your child because we're taking over her education, we have experts who know how to do it better than you, so you're absolved of your obligation," that's kind of like telling a Catholic, "Don't worry if we forbid you from going to church on Sunday because we've ensured that another, more devout person will go in your stead, so you're absolved of your obligation." Well, that's absurd, because the obligation to attend Mass is a personal one. The same is true of parents' obligations to direct the education and upbringing of their children. So policies that make it difficult for parents to fulfill their parental obligations in line with their consciences are a serious violation not only of parental rights, but also of religious freedom. Of course, these rights are not absolute, but because they are so fundamental, a high bar needs to be met before the government is justified in overriding them. I think that high bar is effectively captured by the strict scrutiny standard, for which I also believe there is strong historical warrant, not only in Maurer and Pierce, but also in pre-Maurer parental rights cases decided on the basis of common law. So what does all this mean when it comes to the many controversies related to transgender issues that are now working their way through the courts? First, with regard to the issue of bans on puberty blockers, cross-sex hormones, and surgeries for pediatric gender dysphoria, it seems to me that the state is exercising its well-established authority to regulate the practice of medicine for the sake of public health. Whatever one's view is on this matter, it's hard, on my view, to plausibly claim that there's anything close to medical consensus on the appropriateness and safety of these interventions. given that the UK, Sweden, France, Finland, and other countries have largely stopped providing these treatments for minors with gender dysphoria. In Sweden, the treatments are disallowed outside of clinical trial contexts. And they've decided this after evidence reviews highlighted the significant, often irreversible health risks and uncertain benefits, with some studies showing that mental health problems and suicidality are actually exacerbated by the interventions, as well as concerns about the inability of minors to meaningfully consent to such irreversible changes to their bodies, often including permanent sterility. It's also noteworthy that WPATH, along with many US medical associations, have been criticized by other medical bodies for making recommendations that are not evidence-based and for suppressing evidence contrary to their recommendations. Parents have rights to choose among legally available, medically approved interventions for their children, but no one, not even adults deciding on their own medical treatment, has a right to demand that a medical intervention deemed unsafe by the state be made legally available to them. Second, with regard to controversies over school policies to facilitate a child's social transition to a new gender identity while hiding this from parents, this does seem to me to run afoul of parents' rights, and in many cases free exercise rights as well. Schools can't even give children Tylenol without parental consent, and social transition is much more consequential than a Tylenol. It is in fact a therapeutic intervention for gender dysphoria, in other words, a medical intervention, and it almost always sets children on a pathway toward pharmacological and surgical interventions. Studies have shown that when children do not undergo social transition or take puberty blockers, in around 80 to 90% of cases, pediatric gender dysphoria naturally resolves after children have gone through puberty. On the contrary, when children socially transition, in almost 100% of cases, the transgender identification persists and the children proceed to take cross-sex hormones, starting themselves on a path of lifetime medical dependency and significantly elevating their risk of life-threatening diseases, including various cancers, stroke, and cardiovascular disease. For schools to start children down this medical pathway without the consent or even knowledge of parents is a clear violation of parents' rights, not only with regard to education, but also with regard to medical decision-making. Even transgender rights advocate, former WPATH board member and clinical psychologist Dr. Erica Anderson, who identifies as transgender and has helped many teens transition, believes that parents need to know about and be involved in decisions about how best to care for children with gender dysphoria, and argues that the practice of secretly transitioning children in school is actually harmful to the children that it is intending to help. Finally, what about cases in which parents want to exempt their children from being exposed to certain books or lessons about LGBT issues in school, such as the Montgomery County Mahmoud v. McKnight case? Here too, I think there are strong parental rights and religious liberty grounds for granting such exemptions. As I've argued in a forthcoming Notre Dame Law Review article, circuit court decisions like Mozart v. Hawkins, Brown v. Hot, Sexy, and Safer, and Parker v. Hurley that fail to recognize parents' rights to such exemptions are based on misinterpretations of the true scope and strength of parental rights under Pierce and Maurer, as well as a failure to apply strict scrutiny, which I believe is warranted in all parental rights cases, but which should be granted even under current doctrine, given that these are hybrid rights cases involving both parental rights and free exercise rights. So I could say more about all of this, but in the interest of time, I'll leave it at that for now. Thank you.
Thank you, Professor. Professor Sanders.
So despite the obvious presence of parental rights and religious liberty issues in the background here, the Scrimeti case before the Supreme Court is being litigated as a pure equal protection case. There can be little doubt, I think, that the Tennessee ban at issue in this case would be upheld if ordinary toothless rational basis review applies, the kind we all learned in law school through cases like Williamson versus Lee Optical. So the key question before the court is, should these state bans be required to satisfy some form of heightened scrutiny? The government and the families challenging the bans argue they should get intermediate scrutiny. First argument, because transgender people, they say, qualify as a quasi-suspect class. And although I think there is some good argument that transgender people do qualify under the criteria for quasi-suspect class status, I won't spend further time on that argument because for decades now there's just been no evidence that the Supreme Court is interested in creating new suspect or quasi-suspect classes. The other primary arguments being advanced is that the ban should receive intermediate scrutiny as a form of sex discrimination. As Chip suggested, under these state laws, an adolescent biological male can receive testosterone to treat a condition such as male hypogonadism, but an adolescent female cannot receive testosterone to transition gender. Likewise, an adolescent female is allowed to receive estrogen replacement therapy for certain medical conditions, but an adolescent male cannot receive estrogen to transition gender to female. If this sex discrimination logic is accepted, then it triggers intermediate scrutiny, and a court can evaluate the sufficiency of the state's reasons for this particular line drawing, but it would have to do so with greater rigor and skepticism than under rational basis. The counter-argument offered by Tennessee is that the sex discrimination frame assumes that any administration of these hormones is one and the same treatment. In reality, using testosterone or estrogen off-label for the purpose of gender transition is, they argue, qualitatively different than using testosterone to treat Klinefelter syndrome in boys or using estrogen to treat Turner syndrome in girls. Moreover, the protocols and long-term safety and efficacy of using these hormones for gender transition have been less well established, my understanding anyway, according to the standards demanded for other medical interventions. Another counter to the sex discrimination argument is that these state bans draw lines not on the basis of sex, but on the basis of age, which doesn't trigger heightened scrutiny. So far, at least, Tennessee and other states have made no moves to interfere with transition-related medicine for adults. So where does this leave us? Personally, as someone who identifies as a gay liberal but not a queer progressive, as I like to say, I see good evidence that youth transgender medicine has been corrupted by ideology to a degree that may have clouded scientific and political judgment. As Andrew Sullivan has written, it cannot be transphobic to believe that no child's body should be irreparably altered until they are of an age and a certainty to make the decision themselves. Yet, at the same time, I don't believe we're obligated to take seriously the idea that the bans in Tennessee and other states are the product of what Judge Jeffrey Sutton's opinion for the Sixth Circuit suggested has been a serious, thoughtful, earnest, and profound debate about what's best for children. I find much to admire in Judge Sutton's opinion, which is itself serious, thoughtful, and earnest, but the idea these bans are the products of a well-functioning legislative fact-finding process and not merely a majoritarian stampede is a fairy tale, and I'll explain more about that in a moment. This is an old problem. Must the members of a tiny and vulnerable minority group always be at the mercy of the democratic process and laws enacted by popular majorities? John Hart Ely, no progressive, argued that judicial review was justified to correct abuse and distortion of the political process. And as I heard a wise person say this morning at the opening session, I think one of Judge Duncan's fellow judges, people who need the law most are those whom polls favor least. Now, led by people like my friend Clark Neely of Cato, the libertarian wing of the Federalist Society has long derided traditional rational basis review because it allows for too much arbitrary and unchecked government power over our lives, power that government isn't required to justify with hard evidence and rigorous arguments. Neely and others have advocated instead for what they call judicial engagement. So assuming that judicial engagement here would look roughly something like intermediate scrutiny, I think that's what these bans should receive. The Supreme Court should set that level of review and then send the case back to the Sixth Circuit to consider, drawing on the extensive record evidence assembled in the district court, whether that standard is met. So why is heightened scrutiny appropriate here? Mine is not a sex discrimination argument or a parental rights argument. I think I actually heard Melissa argue for strict scrutiny, but mine is a political process argument. These bans, though in the end they may well be defensible as the kind of regulation of medical practice and child welfare that is the traditional province of state law, these bans were produced as part of an intentional strategy by social and religious conservatives to demonize and scapegoat transgender people. As described in an April 2023 New York Times article, the conservative group American Principles Project actually conducted polling and found that curbing transgender rights had resonance with voters, especially if the focus was on young people. Today, the authors of that article write, the effort to restrict transgender rights has supplanted same-sex marriage as an animating issue for social conservatives. And as we know, stoking dislike and resentment toward everything transgender was a prominent theme of Donald Trump's presidential campaign. And so I would argue there arises a strong inference that these bans are being impelled by scapegoating and appeals to fear. If they could be taken seriously as solely about protecting children from health risks, then ordinary rational basis review might be appropriate. But the record makes clear that for many legislators, these bans were actually about protecting children from being transgender. The statutory findings behind the Tennessee law declare that the state has a, quote, compelling interest in encouraging minors to appreciate their sex. Now, this declared state purpose is not about regulating safety and efficacy of medicine. It is about regulating people's gender choices, disdaining the very idea of being transgender. In South Carolina, another of the states to enact a ban, the Republican House Majority Leader told reporters, "When God created us, he created us male and female, and that's it. There's no other choice." In other words, while insisting for purposes of lawsuits that they're just engaging in ordinary state regulation of medical safety and efficacy, these legislators couldn't stop themselves from saying the quiet part out loud. Intermediate scrutiny, judicial engagement, if you will, provides a principled safeguard against laws motivated by invidious government intent and tyranny of the majority. Its point is to smoke out and acknowledge legislative overreach and illicit motives, of which I think there is evidence here. But let me hasten to add, I think that the anti-trans animus behind these laws need not be the end of the matter. Despite the attitudes that impelled them, they may still be defensible as legitimate regulations of medical safety and the welfare of minors. In fact, if put to that more demanding, heightened scrutiny standard, requiring evidence and actual justification, I predict these laws would meet that standard. And again, I think I heard Melissa say that they would even meet strict scrutiny if the challenge were based on parental rights. We'll see. But while there are many reports of teenagers who have benefited from gender-affirming treatments, the fact is that the science behind these treatments does appear to remain spotty and observational. Many of the European countries that pioneered these therapies have reversed course, as we've heard, having concluded they pose significant risks with unproven benefits. Many of the doctors providing these treatments appear to recognize they're working in an area of essentially experimental medicine. Moreover, recent litigation over Alabama's ban has brought embarrassing revelations of the apparent lack of ethical and scientific integrity behind the protocols for youth trans medicine promulgated by the World Professional Association for Transgender Health, which has been invoked as the respectable scientific authority behind much transgender medicine for years now. These protocols, developed in consultations with officials from the federal HHS, now appear to have been driven, at least in part, by politics and not sound science. So, in conclusion, before the late 1990s, it wasn't medically possible for children to transition genders. Should we continue social, psychological therapy, et cetera? Of course. But it should not be excessively burdensome for states like Tennessee to demonstrate that under a heightened scrutiny standard, risky and potentially life-altering experimentation can at least be regulated, even outlawed, when it involves children. But, and this is my point, they should be required to demonstrate that with evidence, science, and sound arguments, not merely pass off the political abuse of transgender people as a serious and fair lawmaking process. Thank you.
Thank you, Professor. General Miyares.
So I may have a kind of a unique perspective from this, obviously. one of which is, given the fact it's codified in Virginia law, that a parent has a fundamental right to make decisions concerning the upbringing, education, and care of a parent's child. And that has been something that has been, I think, critical to a lot of this debate that's candidly missing in this debate. We are now engaging in arguments that 15 years ago we would have thought was unimaginable. And for me, one of the more eye-opening moments for myself was speaking at an event in Old Town Alexandria, which I guess some would classify as very, very deep blue, and a mom coming up to me saying, I would never, ever, ever in a million years vote for somebody with an R next to their ballot, but I'm going to do so for the first time now. And I obviously said, I'm really honored to have your support. Why? And she said, because we are in a situation where we have too many bureaucrats and too many individuals on school boards that have forgotten a fundamental truth. Never, ever, ever get between a parent and her child. And I thought it was a really remarkable statement that this had brought her to this point. But that's really where we are. It is this idea that we know better than you, breaking one of the most fundamental bonds that you can have as a society. And candidly, whenever I hear an individual essentially say, we know as well for your child as you do, and I have 3 daughters, I always want to ask them, great, what's their name? When's their birthday? What are their dreams and aspirations? And it almost seems redundant that you have to ask that question, but now here we are, where parents are having to spend an exorbitant amount of money to protect something that would not have been debatable even 15 years ago. If I was to say 15 years ago this would be a debate, it would be actually controversial to say parents have a fundamental right to the education upbringing of their children. I would argue most people would say that's an exaggeration, that's non-debatable, don't worry about it. That section of the code was supported when it was put in there by wide support by members of both parties in the General Assembly. And now that is somehow considered by some media outlets, legacy media outlets, gaslighting. I find that utterly remarkable. And then we're saying what's kind of an ironic moment, what's happening in Europe versus what's happening in the United States. Europe has gone down this path and is now slowly looking at the science, looking at the data, and reaching dramatically different conclusions of what we're seeing in the United States. And I like to joke, there's going to be trial lawyers 10 or 15 years from now that are going to be able to retire early as this comes out to light. I'm fully convinced of that. Let's look at what happened in England. You had Dr. Hilary Cass did the Cass report with the National Institute of Health, an absolutely damning indictment on transition surgeries that have been happening in England for minors under their NIH program. They have now banned it. They have stopped it. No longer NIH will do these surgeries. Finland, France, several other European countries have looked at the data, looked at the science, and have reversed course. Now, it reminds me of a great quote from C.S. Lewis, who says, the progressive man is not the man who walks down the wrong path and keeps walking. The progressive man is the one who realizes they're in error and turns around. Europe is turning around. Now, we often hear trust the science. Well, let's look what's happened in the United States. News reports that were released in October, just not even a month ago. We had, in 2015, $10 million of your money, taxpayer money, grant money, from the NIH went to Joanna Kennedy for an extensive surgery following 95 children over the course of 2 years that have gone through this process of gender-affirming care and puberty blockers. Let's look at what came out of this. The significant portions of the children in the cohort experienced serious problems before the medical treatment. With this medical treatment, they experience, in some cases, even worse problems after the treatment. Over 1/4 are suddenly dealing with anxiety at a higher level than before. Now, the New York Times article that published the story made this notation that this is a study that's been in place for 9 years, but they will not release it. In other words, trust the gender science that we won't release to the public. And so we're in this kind of unique position where they have openly said, we're worried about releasing this data, this 9-year study looking at 95 individuals that have gone through transition. We will not release it to the public because at the end of the day, we don't like the results and we think it could be used against us in court, which is a remarkable moment, is it not? I'm a big believer that sometimes shining a light's the best disinfectant that we can have for government. And so now we're at this stage going back to parental rights of these lawsuits that are now being filed really all over the country. And yes, Virginia is part of it, yes. Governor Duncan did issue guidelines and directives on this to school districts, which is a really simple idea of parents have to be involved. And Melissa made a great point. You cannot give your child, a school district cannot give your child so much as an aspirin in school without explicit parental permission. But they now argue that they have a right to change your child's gender pronouns and identity and intentionally hide it from the parents. If I was to say that to you 10 or 15 years ago, you would fall out of your chair and say, wow, that is insane rhetoric. That's irresponsible that you would ever think that we would go down to this path, but that's where we are. And so as often the case, when you have what I think is a fundamental right as a parent that we've seen being violated, this is now being litigated, obviously, in the courts. And as Attorney General, obviously, you wear a lot of hats, but I think protecting parental rights is one of the most critical duties I have as Attorney General. I could think of one of the most important functions you have is protecting what should not be a novel idea, that indeed you have that fundamental right to the education upbringing of your children. Obviously, there's a lot of cases that have been filed. U.S. committee is by far and away the largest one has been touched on. But it simply really argues that the Tennessee law falls within the state's traditional authority to regulate medicine, and that the equal protection challenge fails because courts cannot override legislative policy judgments, especially in resolving ongoing disputes about medical interventions. Now, we've joined amicus briefs, Virginia has, in Arkansas, Oklahoma, Idaho, but this is going to be a consequential case heading in for sure for this term. Now, it's been mentioned about, and if I'm getting this name wrong, Professor, please correct me. Eau Claire, is that the correct pronunciation? Eau Claire. Okay, sorry. I don't know if we have anybody from Wisconsin here. They implemented a policy that allows school administrators to facilitate social transition for a child without informing or seeking consent from their parents. So obviously, it's been noted that's been challenged. Seventh Circuit noted they did not have standing, and they're seeking Supreme Court review. Now, we also joined an amicus brief supporting a cert petition with 15 other states, arguing that parents actually do have a standing to challenge a school policy that would interfere with the relationship of their children. It also argues that the Supreme Court should grant review of this case because of the importance of this parental rights issues. Parents' rights to raise and educate their children should be protected. Again, Supreme Court, we're asking to intervene because what was not once debatable is now debatable. So we're really anxious to see the Supreme Court step in. We have seen like-minded states, probably you can guess the states that have lined up on one end or the other, but I do think this is going to be, parental rights is one of the huge legal challenges of our time. And it goes back to that idea that, again, you, the parent, has a fundamental right to make these major decisions affecting your child's life. It is essential that schools work with parents, not against parents, to support their child's well-being, and that government officials cannot simply override a parent's fundamental right simply because they know better. We've also, one thing that we've often seen with our state AGs is that oftentimes we are at the front line of defense on regulatory overreach. And that is the one thing that has probably surprised me, probably one of the most in this job. I asked every former Republican AG before I took office, what is one thing that you learned by your last day in office that you wish you had known by your first day in office? And every single one said the impact you can have on regulatory overreach. Our team did an analysis of all the laws and regulations passed during the Biden-Harris administration. Less than 5% have been acts of Congress. Less than 5%. Now, there's probably people in this room that think that's great. That's what we want. We want an unelected administrative state or executive orders to regulate every aspect of our life. I think that goes so against the founding principles of what this country is. It goes to what James Madison, Virginian by the way, what James Madison wrote in the Federalist Papers, where he said that separation of powers, the idea of how it would continue to work with that each branch of government would jealously guard their power. When reality is, one branch of government has decided to stop being a lawmaking body. Congress has not passed a budget since grunge was popular. You can look up grunge and when it was popular. It was during the Clinton presidency. They essentially passed continuing resolutions and they confirmed judges, which is incredibly important, but they've essentially stopped being a lawmaking body. And so in some ways, you could make an argument that the branches of government now are the presidency, the judiciary, and an unelected administrative state that could promulgate rules and regulations that can have an enormous impact on the everyday lives of everyday Americans. And the point I've always made is, and the lawmakers love this, by the way, because the one thing a lawmaker never wants to do is they never want to be on the board on a bad vote. So they love this. So people argue, why is Washington broken? They don't have to work together anymore to do anything. That's part of it. And that's a whole separate discussion on Chevron deference being overturned in the administrative state. But it goes to a big aspect of what we do. And so in July, Virginia and 14 other states secured a nationwide injunction against the Biden administration's Section 1557 regulations, which would have barred sex-separated hospital rooms and bathrooms and forced doctors to provide gender transition drugs and surgeries to children. This is Section 1557 in the Affordable Care Act, which would incorporate Title IX's prohibition on discrimination on the basis of sex in the healthcare space. Now, I'll get to that in a second. Well, practically speaking, it would have barred sex-segregated hospital rooms or bathrooms and forced doctors and nurses to use preferred pronouns, even if it was in violation of their religious liberty, and required doctors and hospitals to provide gender transition surgeries and hormone drugs, even to children, and require states to subsidize these procedures through Medicaid. Huge policy change, not an act of Congress. Do you think your average congressman or senator want to be on the board voting for that? The answer is no. And so I think one of the most important things, we're very pleased with the nationwide injunction. We think there will be a different change in this administration, the incoming administration. But I do think it goes back in many ways to what a functioning democracy looks like, which is this novel idea of accountability to its citizens. And part of the frustration you're seeing with parents, and they're not scapegoating anyone, is they feel like nobody's listening. They feel their fundamental rights, some of the most cherished rights and liberties, which they used to wake up every day in this country and just take for granted, are suddenly being challenged yet again by people that think they know better. And so I think this is going to be one of the defining moments of my time, and me personally, because I often hear my dear friends on the left talk about being on the right side of history. I have a feeling 10 or 15 or 20 years from now, we're going to look back at this debate and shake our heads at some of the arguments that were advanced to go after parental rights in this space. And we have seen in Europe, they've seen the data, and they are turning around. And obviously my hope is that Virginia and the United States will also take, I don't normally say this, follow Europe's lead. Follow Europe's lead and really take something that is really hard for those in some of their places of power, have a sense of humility maybe we got it wrong. When was the last time you heard somebody in a position of power admit that? It's very, very against human nature. And so my hope they look at Europe that gives them the cover to say, you know what, we've looked at the data. The best way to fight bad information, as I tell my team all the time, is with good information. That we get the data and we're able to take a sober analysis of where we are as we debate, I think, really one of the fundamental issues, I think, of our time, particularly when it comes to parental rights. Thank you.
Thank you, General. Now, I'd like the panel to be able to sort of respond to each other and talk amongst themselves for maybe 10, 15 minutes, and then we're going to have questions from the audience. Chip, back to you. I know you wanted to maybe add something about religious liberty or respond to what
I
your
have
co-panel.
too many, Kyle, I'm sorry, Judge Duncan, I have too many things.
Call me Kyle.
Too many things to say. So let me make 2 points about religious liberty and then a few, small, quickly, and then a few observations.
Microphone.
Oh, now I have to do that? So, okay, sorry. Okay, so the religious freedom points. If the Tennessee law is upheld, as I think a lot of us think it will be, banning, gender-affirming care for adolescents, Tennessee has a Religious Freedom Restoration Act. And for parents who are religiously motivated to provide this kind of care for their children, they're going to have an interesting religious freedom claim. They are burdened in their religious freedom if this law stops them from engaging in medical transition. And does the state have a compelling interest to stop it? Well, maybe, but that's, then we know we have strict scrutiny. And we know we have a different kind of argument. No one's been talking about this except for me so far, but I think we're going to find some religious parents who are going to make that claim, and maybe religious doctors to work with them because they have religious motivation to provide the care. With respect to parental notice from schools, there is at least one case out of a district court in California that held that a teacher in a school that prohibited disclosure to parents, that a teacher had a free exercise clause right to go ahead and tell the parents, and the school could not discipline that teacher. Now, I understand the problem of conscience that the teacher faces, but I think as a matter of law, that's an outrageously wrong decision. This is a public employee, and speaking as a public employee, and the school system has said, don't tell the parents certain things unless we, the system, approve. And the teacher is going off on her own to do it. So we all understand the impulse, but as a speech case or as a free exercise case, that seems to me quite wrong. Now, a few observations about my fellow panelists. First of all, they were all sort of with me about parental rights. Parental rights are good; they're important. Professor Moschella said so. General Miyares said so. Implicit in what Steve was saying, parental rights are good and important, and we should respect them. But then they just draw back short on the question of whether parents can authorize the medical transition through pharmaceutical products, not surgery. I wasn't talking about surgery. They stopped short of that. They wanted to change the subject to notice, or they wanted to draw some line. And Professor Moschella said, well, the parents should be limited by what's legally available. So notice, in Maurer against Nebraska, the parents were not limited by what was legally available because the state had said no studying modern foreign languages in school. You can study other things, but you can't study that. It's not legally available. And Maurer says, no, the parents have the right to choose that kind of study for their children. In Pierce, the state said legally available school, public schools only. And the parents said, no, we want Catholic school. We want a military school. And the Supreme Court said they are not limited to what the state of Oregon has said is legally available. So the idea that legal availability is going to be the measure here is quite inconsistent with the 100 years of jurisprudence on this. If you're serious that abuse and neglect is the limit, I agree with that, then I think you have to show that parents who authorize and agree to these treatments after medical consultation are engaging in abusive treatment of their children. That is a much more difficult showing to make. I haven't heard you try to make it. I haven't heard anybody try to make it. I understand the doubts and concerns about the science. I understand them thoroughly. I've been thinking about this and writing about it for a year and a half, and new information has come across. We're left with a question about who decides and whether parents learning all of this about the science, absorbing it, making a judgment about whether this is the right treatment for their children. That, to me, should be left to families in light of the science, not to the state, because some of the science has proved untrustworthy.
Thank you.
Could I?
Muscat. Go ahead, please.
Oh, sure. So yes, I'll just respond briefly to some of Professor Lupu's comments there. I don't think that there is a parallel between what happened in Pierce saying, well, you can go send your children to the legally available schools, namely the public schools, and nothing else. I think that the issue of the state's power to regulate medicine is a completely independent issue. So again, I think looking at this by analogy with the rights of any individual adult to make medical decisions is instructive, right? I, as an adult, if I wanted to get some medical treatment that is not currently approved by the government, I would not be able to get it, right? Parents have the rights to make the decisions for their children that are analogous to the rights that adults have to make for themselves. So I think the parallel simply doesn't work because we're dealing with a different layer of state regulation over the medical profession more generally. It's not really about the state interfering in a parent's decision. It's about the state trying to protect parents and especially their children from a medical establishment that the state, I think with good reason, has judged corrupt in a variety of ways because the medical establishment currently is not following the science on these matters. And so the state is stepping in to protect everybody from this basically vast malpractice is how I think of it. So I think really that's the main issue. Just a quick response to the claim that some of these bans on puberty blockers and other interventions for minors with gender dysphoria, that they are motivated by animus towards people who identify as transgender. I don't think that a New York Times article that claims that they're motivated by animus is evidence of animus on these matters, nor do I think that a state saying, actually, we have an interest in our citizens recognizing the existence of biological reality and the existence that as a species we are biologically males and females, and that the only way that we can continue the species and continue to grow and prosper as a nation is if a significant percentage of the citizens engage in procreative activity that will allow the reproduction of society over time. This is actually a really important state interest. And so engaging in legislation that preempts minors from sterilizing themselves before they really understand what they're doing, I mean, that seems like a really important state interest in and of itself, even apart from the other things. So I don't think there's any animus there. I do think there's a legitimate interest, and also I think a general judgment, which some people may disagree with, that on balance, it's better for a person to come to accept their own bodily identity rather than to spend their lives dependent on the medical establishment with all the attendant risks and health issues that go along with that.
Thank you. Professor Sanders.
Just a couple of responses. First to Melissa. I guess I just don't think it's objectively possible, looking at the political climate, looking at the arguments and policies advanced by the political party that most of these state legislators are members of, to say that there has not been a legal and political campaign of demonization and scapegoating of transgender people, which makes the enactment of these bans seem more compelling and more justified. I heard Melissa sort of scoff at the idea that parents should defer to the expertise of trained teachers about curricular matters or books or whatever, yet we're willing to defer to the views of legislators who might be small-town lawyers or real estate agents or, whatever, about how people should raise their children and whether, we should all strive toward an ideal of procreation and force people to accept something that they don't want to accept. Anyway, that aside, I want to try to reconcile maybe the distance, if there is any, between Chip and myself. I'm very much in sympathy with Chip's basic point and with the thrust of his remarks. What I have found challenging as somebody who's interested in this issue, who likes to think that I have an open mind in both directions, I found it difficult to absorb or find good objective evidence of the science and the medicine behind transgender medicine, especially as it pertains to youths. To me, I just can't believe that the vast majority of parents, as caring and well-intentioned and diligent as they might be, are in a position to make a full evaluation of the science and the risks behind these therapies. They depend, unlike the decision of what school to send your child to or how to raise the child in your home or what the child's religious practices should be. Let's face it, these parents depend on, are at the mercy of, doctors and medical professionals. I just don't think that the average parent, again, their judgment has to be respected, but they have to rely on what they are believing and assuming and hoping is objective, sound medical advice and science by medical practitioners. What troubles me, especially now in the wake of the most recent revelations about WPATH and so forth, is that that may not be there, that the people guiding these parents may be motivated as much, or the people who are setting the standards that the practitioners look to have been guided as much by politics, by gender theory, and by a concern about what they want, about an ideological agenda, as opposed to sound objective science. If we could assume that these parents have available to them the best quality, objective, rigorous science about the risks and benefits, the efficacy, the safety of these procedures for youth, I would be firmly in Chip's camp. The reading that I have done, the controversy that I have tried to keep abreast of, suggests that there are too many troubling suggestions that we, in fact, cannot, at this point, trust and rely on the medical authorities that have been upheld. Many of us have cited them in amicus briefs, organizations like WPATH, about just how safe and effective these treatments actually are.
Thank you, Professor.
I mean,
General,
I
would
think
you like
it's,
to add anything?
sorry. I do think there's probably been some arguments from stage, perhaps taking some of the Religious Freedom Restoration Acts to perhaps a direction that if you reach a logical conclusion, I think the professor would acknowledge that if a parent was to suddenly say, my religious beliefs dictate that I can give my child LSD and makes them closer to God, I want to give my 12-year-old LSD, it's my religious freedom. And I'm sure the professor would say, no, that would not be the case. Or acid, or any other types of drugs that would be incredibly harmful to the child. If someone was to show up in court, Child Protective Services has taken him to court and says, I've given my child acid to make him closer to God as my religious beliefs, we all know in the room what the result would be. But somehow we could say we can give them puberty blockers and other aspects to help them with gender-affirming care, which, for example, if I was to go in to say, I suddenly want to castrate my child, and it's part of my religious beliefs, I think everybody would recognize that's a very, very different standard. Or give a 17 or 16 or 15-year-old girl a double mastectomy, or give them drugs that have sterilized them when they're age 13. And so I think all of us would argue at that stage that there is a potential compelling interest by the state at that moment. So obviously it's always a balancing test, but we've always drawn red lines before dealing with the religious liberty standards and parental rights, obviously. And to me, you can just take out, if you remove the transgender and gender affirming care, and like as I said, somebody came in to the court and said part of my religious belief is to castrate my child, I think all of us would say, no, I think there's a compelling interest at that stage for the best interest of the child for the state to have some bright line rules. So I think as you kind of, and I'm really encouraged that there's this heightened interest in religious liberty and Religious Freedom Restoration Acts, but I do think that we can all recognize how that would be applied when you take it to its logical conclusion.
Thank you. Now, do we want to have some questions? Do we have questions here? Please, go ahead, just, you know, actually phrase it in the form of a question.
What's a question?
Well, a question ends in a question mark. Can you hear?
No, do you have a microphone?
Just
Because-
speak up.
I have a hearing deficit, so I'm going to do my best to, you do have a mic, and, okay, you ask your question.
How about now? My name is Josh, and I'm an attorney from Kansas, and my question is for Professor Lupu and also the panel. I don't know if this is the case that you were referring to, but I represented Pamela Rickard, who was a middle school teacher in Junction City, Kansas, who was disciplined by the school board for not only failing to use the correct pronouns, but also ultimately asked the school board for leave from the policy that would require her to use one name with the parents and another name or pronouns with the student in the classroom.
Okay.
And so ultimately we filed suit in federal court and prevailed, not on the free speech grounds because the school board had relaxed that policy, but on the free exercise grounds, which ultimately our client was saying that the school policy forces her to lie and therefore it violates her religious freedom. And so an interesting part, and I'll get to the question quickly, interesting part in the questioning of the federal district court judge was what name and pronouns should the teacher use during parent-teacher conferences with the students sitting right there. And the interesting response to the school district was, well, nowadays the student really drives the parent-teacher conferences, and I wouldn't think that the teacher would have to speak much at all. And so ultimately, our client was successful on those grounds. That said, one thing that came up and this is my question, came up in the school district's argument was that they had to close the records related to the pronouns and name of the child, preferred name, because of FERPA, Federal Education Rights and Privacy Act. And we obviously got up and said, you know, I thought that was for parental rights to those records. So especially with your comment regarding the parent can just take the kid out of school, how would the parent know to do that if they don't have access to records of what's happening with their children? And is there any case law related to FERPA that would inform this discussion?
Okay, I heard 70% of that. I think that was enough for me to get the gist of your question. If you'll hear my answer, and I think it will be responsive. I'll do my best. Not for a minute would I defend a school system that encouraged lying to a parent. If the school system is saying to teachers, now you call this child Michelle in school because that's what she wants, but she's Michael when her parents come in, they are lying to the parents, okay? That is deceitful behavior, and that is wrong, and that is bad, and what the legal consequences could be for whom, we need to, maybe I missed some of the pieces about discipline for the teacher, what might happen to whom. That's just bad behavior, okay? Schools cannot be dishonest with parents. That doesn't mean that they have to tell parents immediately when a child comes in and says, you know, I'm in distress, I feel like I'm a girl and not a boy, I want to talk to someone about it, I'm thinking about using a different name, and explores that with a counselor. I don't think that's a smart moment, and please don't tell my parents, because if you do, something bad will happen to me at home. I don't think that's a smart moment for the school to go run to the parents, okay? This is now a delicate situation, and it has to be managed. So I don't know if I was completely responsive to the question, but I hope I was.
Thank you. Thank you. Next question, please.
Thank you. Coach Winehouse, I run a nonprofit, childrenofthecourt.org, originally a student project for my class at UCLA, now funded by a court order. Among other things, we promote the idea of relevant judicial experience, such as only assigning cases involving parental rights to those judges with parental experience or active members of the foster system. Professor Sanders says we can't trust medical professionals. Professor Lupu says the whole panel likely draws a line in what is often a judicial determination and abuse or neglect. Aside from the standard of review from a handful of statutes, very well debated today, thank you, what risks, if any, do actual parents face from trial judges who lack relevant parental experience and who are making these decisions for them, absent statute or federal protection due to application of Worker-Feldman or the domestic relations exception to federal jurisdiction?
Okay, does anybody, this question is about sort of judicial competence, I guess, to rule on these cases. Anybody want to take a stab at that? I mean, of course, I don't think, speaking as a judge, there couldn't be a requirement that judges have parental experience before, I think I'm on firm ground here. Just like there couldn't be a requirement that a judge be, an oil and gas worker before ruling on an Oxla case in the Fifth Circuit. But so that's, leaving that to one side, is there some relevance to sort of the judicial, I guess the judicial competence in ruling on these cases?
I mean, I think and there may well be good and interesting arguments. My initial reaction is it reminds me of the argument that, only a black judge should adjudicate a race discrimination case or something like that. But, I mean, for better or worse, judges, and Judge Duncan can tell us more better than the rest of us, are generalists. There's probably often a price that's paid when non-experts, have to make a difficult decision about an intellectual property matter or something like that. But I mean, judges are generalists. They are supposed to be neutrals. They are not supposed to be, well, I'm a counselor, I'm sympathetic with you, so I'm going to we're going to figure out what what, as parents, what we want for children. The idea just strikes me as a bit odd.
Yeah. Okay, thank you. Question?
David Axelman from Tallahassee, Florida. My question is for Professor Sanders. So I heard you say that, or at least suggest that the states that have prohibited so-called gender-affirming care for minors have not really grappled with the issue seriously or engaged in good faith policymaking. Instead, it's just been animus. I spent the past couple of years working at the Florida House of Representatives. We're one of the states, of course, that has passed such a law. And I'll tell you that our House committees heard testimony from detransitioners such as Tony Cole, who testified about the harm that she experienced as an adolescent, who was treated with these puberty blockers, cross-sex hormones. We heard from parents on both sides of the issue who testified about the harm to their families, some testified in favor of it. I guess my question, and I suspect that all, or at least most of the other state legislatures who passed these laws also heard testimony. My question for you is, what more do you think is necessary for a state legislature to demonstrate that it actually grappled with these issues and engaged in good faith policymaking? And relatedly, if that's all good and well, but as long as a few legislators come out with, make derogatory comments about transgender people, is it your position that that then suffices to impose heightened scrutiny, even though we're not dealing with a suspect class?
Yeah, I see heightened scrutiny, as I said, as a matter of political process. There's a line of scholarship under the Equal Protection Clause about animus. Cases like Cleburne versus Cleburne Learning Center, Romer, have held that increased heightened judicial scrutiny is justified when there is evidence that a small, powerless minority is being targeted in some way, separate from quasi-suspect class status. These cases haven't made these groups suspect classes or quasi-suspect classes. They've just said on a case-by-case basis, a closer judicial look, judicial engagement might be relevant. I apologize if I came across making an oversimplified statement. As I said, I believe that the states, if put to the test if this evidence is submitted to a court, can overcome, can meet the requirements of intermediate scrutiny or judicial engagement. So I did not say these bans should fall because they've been impelled by animus. I'm saying the political climate in which they were passed, the fact you have 22 states in a matter of a year or two all deciding to do the same thing, all rushing headlong toward a perceived policy imperative. None of us know whether the process in some states has been as good as and rigorous as it was in Florida. So again, what I'm saying is there is some evidence here of a small, unpopular, defenseless, relatively defenseless minority having its rights endangered by a hostile political majority, at least in these states. That doesn't mean the bans are automatically struck down. It just means they shouldn't get nothing more than rational basis review, which is essentially toothless. As I tried to say at the end of my comments, I'm actually reasonably confident, based on the kind of evidence and thoughtful process you suggested that the Florida legislature went through, that these bans will stand up to scrutiny. My point is just that they should get scrutiny, not just the easy, toothless pass of rational basis review.
Thank you. Next question.
Thank you. My name is Stephen Taft. I'm the former president of the Richmond chapter of FedSoc and a PC lawyer. The previous questioner almost perfectly anticipated my own, so what I'm going to do is zero in on an aspect of this question of are we really dealing with the suspect class, and if not, is animus even a legal argument, or whether or not it's a moral one. So what I assumed listening to the panel is where you were all going with the animus argument was perhaps Justice Kennedy's line of cases about substantive due process regarding homosexual rights, for example, where there you see an animus, and essentially it didn't even meet rational basis because of the animus, given that he concluded and others that this was a class that was deserving of protection. Now, as the Attorney General here mentioned, well, we don't even know where the politics are going to go on this. So what I would like to ask is this. Essentially, do you all anticipate a evolution, a continuation of that Kennedy-esque substantive due process argument being extended to other classes like this? Or do you think, as the Dobbs case signals to some, that there's going to be a reimagining of where we draw the line on these issues? And therefore, what do you all think is the implications for jurisprudence on the trans movement?
Well, and if I may say, I mean, so part of that question is the Supreme Court in many areas, Dobbs included, seems to be much more interested in history and tradition, Second Amendment, for example. How is that going to affect, if at all, this inquiry?
I'd like,
Yep, go ahead.
may I?
Please.
Well, Dobbs, due process, history, the Second Amendment, history and tradition are supposed to play a significant part. We know that. And, I started my opening remarks by talking about the way history and tradition and common law and statutory law support the idea of parents' rights. Now, and they're not new. They go back. They go back a ways. This is not about animus. This is about Maurer and Pierce might have involved animus, but they weren't. The opinions don't talk about animus. The opinions talk about parents' rights. Now, in the Seventh Circuit case that was decided just yesterday on this point, and likewise in the 11th Circuit case that was decided a year ago, and we haven't talked about this. Both the judges, both in the majority, both said, well, these puberty blockers and these hormones were not available in 1868. So parents couldn't have a right to use them because they didn't exist. Now, I think that was just silly, okay? The rights in 1868 were not controlled or limited by the FDA or rules about legally available. There was just an open market on the use of drugs and medicine, and there was tort law that was a boundary. So if your rights are limited to what was available in 1868, you can't use penicillin, and you can't teach your kid artificial intelligence if the state says so, because we didn't know about it in 1868. Their 1868 rights can't be understood so narrowly about available choices. They have to be understood in terms of genres or category of regulation. And I think the parents' rights, I'm bracketing equal protection for a minute. the parents' rights meet this tradition, this test of history and tradition. Now, I just want to say one thing about equal protection, where I think that line of inquiry is just inappropriate, because a lot of the history and tradition of equality in the 19th century in the United States is very hostile to people of color and very hostile to women. And if we're going to look back to the world in 1868 about norms of equality, equal protection jurisprudence is going to get undone. So the court has never said equal protection should be construed in light of history and tradition. And if it did, that would be a very reactionary move.
If I could just add to that briefly, yeah, I mean, I completely agree. If there is any right that is currently rooted in the Due Process Clause that meets the history, tradition, as well as essential for ordered liberty Glucksberg test, it would be parental rights. And in fact, I think an investigation of the history and tradition would give you a stronger set of constitutional parental rights than the way current interpretations have gone. On the issue about heightened scrutiny for certain minorities, I mean, I think Chip's right that the court has not said anything about history and tradition tests for equal protection jurisprudence. But I do think the issue of transgender and LGBT rights in general fitting into the idea of discrete and insular minorities seems rather odd, right? The idea was you take a completely politically disempowered group, somebody who doesn't have access to the general political channels in order to make their claims, and that's why they need special judicial protection. A group that is the favored group of one of the two political parties in the nation, and also dominant in all the universities, dominant in all the public schools. I mean, in other words, a group that has very significant political, cultural, social power. It seems hard for me to think that group could count as a discrete and insular minority.
Steve, did you
I
want to
think there are interesting substantive due process arguments about protecting transgender people. I'm not sure they apply to children. But all of the cases that I was relying on in this kind of animus line of cases that just say you ratchet up the level of review when there are potentially bad motives evident in the public debate and discourse and passing of a law, they're all equal protection cases, not substantive due process. Department of Agriculture versus Moreno, Cleburne versus Cleburne Living Center, Romer, and Windsor are all clearly doctrinally equal protection cases. Just on the history point, though, I would say there are, very well-respected card-carrying originalists who have gotten their minds around the idea, and Stephen Calabrese wrote an article saying Obergefell was justified by an original understanding of the Equal Protection Clause because the original understanding of the Equal Protection Clause was to create an anti-caste principle, a principle that law can't put people in castes and disadvantage them categorically without strong, good, compelling arguments and reasons.
Thank you. I wish I had time for all the questions. We have time for one more. Please.
I have two, but I'll make them.
Just one. Thanks.
This one is for Professor Lupu. I believe I heard you say that when you're taking the position that if schools are not a, quote, safe place for these children to have these conversations about purported gender identity issues, there is no safe place for that child to have that conversation. And that struck me as odd, because I have a question, two parts. One, what is the role of the physician, your understanding of the physician-patient privilege as it respects to minors seeking medical advice on those issues, and would those be privileged? And does that then create a safe space?
Okay, it was the question is I believe about if a minor seeks advice of a physician, right? Maybe in the school setting. No.
Oh, okay, I think I did
And-
understand the question. My remarks about an adolescent needing a safe place to have a conversation was not a remark about a conversation with a physician who might then be prescribing medical substances for transition. I was talking about a school counselor who at the most can initiate discussion of a plan about social transition, names, pronouns, restrooms. If a child is talking to a physician about anything so serious as this, of course their parent or guardian should be there and should be getting information from the doctor about choices and options and risks and trade-offs and all of that. So maybe I wasn't understood, or maybe I missed an edge on the question, but I certainly never suggested that conversations between the child and the physician should be private with parents excluded. Absolutely not.
Thank you. All right, we are unfortunately out of time. I've been told to make these announcements, and I do what I'm told. A couple of brief announcements before we wrap up. I'm even reading it. First, if you're pursuing CLE, please be sure to check out by scanning the QR code you scanned when you checked in. Second, we encourage you to have conversations with and get to know your fellow attendees or our panelists, but as long as they want to. But if you could do so outside this room so that we can close down for the evening, that would be most appreciated. Wow. Okay, sorry about that. I think that means get out. With that, thank you. Let's join the panel and thank the panel for a great discussion.
Well done.
I'm in it. When I was young in my career, you were very